Welcome back to the deep dive. Today, we're tackling a really significant piece of law. It governs, well, pretty much everything about the South African coast.
That's right. We're looking at the National Environmental Management, Integrated Coastal Management Act of 2008, the ICM Act.
The ICM Act. And our mission is basically to unpack this, make it clear for anyone interested, whether you're into environmental law, conservation, or maybe you just want to know your rights when you go to the beach.
Exactly. And it's important to remember this isn't some dusty old law. It's consolidated, yes, but it's been actively rolling out. Assented in 2009, but bits and pieces only commenced, right up to 2020.
And it's already been amended too, right, in 2014 and 2022?
Correct. It's a living piece of legislation, very much so. It has to be, given what it covers. For anyone who lives near, works on, or just visits the coast, this act is, well, fundamental.
Okay, let's start right at the beginning, the motivation. Why did South Africa feel the need for a specific integrated law just for the coast? Weren't existing environmental laws enough?
That's a great question. The preamble itself gives us the answer. It paints the coastal zone as this really unique intersection. It's biophysical, obviously, but also economic, social, institutional. It's complex.
So it needed its own dedicated rule book.
Pretty much. And it's driven directly by the Constitution, the right to environmental protection, not just for us now, but for future generations too. Crucially, the Act acknowledges something quite stark.
Which is?
That historically the benefits from the coast, economic, environmental, have been, and I quote, distributed unfairly.
Ah, okay. So there's a redress element baked in from the start.
Absolutely. The Act is designed to try and correct that historical imbalance, to manage the coast for the benefit of all South Africans, and to do so permanently.
That sets a pretty high bar. So what are the kind of main pillars the Act rests on? What are its core objectives?
Well, Section 2 lays them out. First, you need to actually define the boundaries. What is the coastal zone, legally speaking?
Makes sense. You can't manage what you haven't defined.
Exactly. Second, it's about integrated management, getting all spheres of government, national, provincial, municipal, to work together. Cooperative governance.
Right. Avoid silos.
Third, and this is really key, is preserving, protecting, and even extending coastal public property. This is the stuff the state holds in trust.
We'll definitely need to unpack that in-trust idea. And the fourth?
Ensuring equitable access for the public, and also making sure South Africa meets its international obligations for managing the marine environment.
Okay, that state holding property in trust concept feels central. Let's dive into the legal geography. If I'm standing on a beach, what's mine, what's public? Define these layers for us.
Okay, so the coastal zone is the big umbrella term. Underneath that, you have several components. Coastal public property, the coastal protection zone, coastal access land, coastal protected areas, the seashore, and coastal waters.
Wow, okay, lots of layers. Let's start with the big one, coastal public property, or CPP. What does that include?
All right, CPP is defined in Section 7. It's the coastal waters themselves, the seabed beneath them, any natural islands out there, and critically for most people, the seashore.
And the seashore is?
It's that area between the low water mark and the high water mark. So, the wet sand when the tide goes out and the sand up to where the tide normally reaches, that's CPP.
So if I'm on the beach, I'm technically on land owned by everyone.
That's the core concept, yes. Section 11 is explicit. Ownership vests in the citizens of the Republic. The state doesn't own it in the normal sense. It holds it in trust for the citizens.
Like a guardian.
Exactly like a guardian. And this trust status is legally powerful. It means CPP is inalienable.
Meaning?
It can't be sold. It can't be used as collateral for debt. You can't claim ownership just by occupying it for a long time, what lawyers call prescription. It's fundamentally protected against privatization.
And what about just walking on it? My right to access?
Section 13 covers that. As a natural person, you have a right to reasonable access and use of CPP, like the seashore. The big condition is that your use mustn't cause an adverse effect, damage the environment basically, or get in the way of the state's duty to protect it.
So those stories you hear about people trying to charge fees just to walk on a beach?
Generally illegal under this act. You can't charge an access fee for CPP without the minister's specific approval. Now, they can charge you for using specific facilities built on the property like, say, parking or toilets, or maybe access to a formal protected area within it, but not for just accessing the beach itself.
Okay, that's clear. Let's move just inland then. This is where private property often starts. Tell us about the Coastal Protection Zone, the CPZ. How far inland does the state's influence reach here?
Right. The CPZ is essentially a buffer zone. It includes those really dynamic, unstable areas right next to the sea, like natural dunes that aren't technically CPP yet. But the key part for property owners is the boundary.
How's it defined?
It includes any land unit situated wholly or partly within 100 meters inland from the high water mark.
100 meters. That's quite a significant strip of land for coastal properties.
It is. And it can be even wider. If the land adjacent to that 100-meter zone is zoned for agriculture or its use is undetermined, the CPZ actually extends up to 1 kilometer inland from the high water mark.
A whole kilometer. Wow. So what's the purpose of restricting use that far inland? Is it purely conservation?
It's broader than just conservation, though that's part of it. Section 17 outlines the purpose. It's about managing, regulating, or restricting land use there to achieve three main things. One, protect the ecological or even aesthetic value of the public coast nearby.
Okay.
Two, critically, avoid increasing the severity of natural hazards. And the Act specifically calls out the risk from sea level rise here.
So preventative planning,
Yeah.
building restrictions to avoid future disaster claims, perhaps.
Exactly. And third, it's to maintain the natural functioning of that dynamic coastal edge, the littoral active zone, the beaches and dunes. Let them do their job naturally.
This brings us to something really, really crucial, especially with sea level rise. The coast isn't static. What happens when that high water mark, the boundary line, physically moves inland because of erosion?
Ah, yes. Section 14. This is probably the most challenging part of the Act for private coastal landowners. First, it's important how the high water mark, the HWM, is defined. It specifically excludes those extreme water lines reached only during, say, a massive storm surge or freak waves.
Okay, so it's the normal high tide line.
Sort of, yes, the ordinary reach. But here's the rule. If that HWM moves landward, maybe due to gradual erosion, maybe due to sea level rise, the legal boundary of the private coastal property moves with it.
Wait, hang on. You mean if my beachfront plot slowly gets eaten away by the sea, I actually lose legal ownership of the bit that's now below the new high water mark?
That is precisely what Section 14 says.
Yeah.
The portion of the land that falls below the new landward HWM ceases to be private property. It automatically becomes coastal public property.
It becomes part of the seashore, owned by the citizens in trust.
Correct. It vests in the citizens, held in trust by the state.
And compensation? Surely if the state effectively takes your land due to natural processes.
This is the really stark part. The Act is explicit. The owner is not entitled to compensation from the state for that loss of land.
No compensation. At all.
Not unless, and this is the only exception, the movement of the HWM was directly caused by an intentional or negligent act or omission by an organ of state.
So, unless the government actively did something wrong that caused the erosion, if it's just natural processes or climate change, tough luck.
Essentially, yes. It codifies the inherent risk of owning property right on a dynamic coastline. The law prioritizes the public trust obligation over individual property loss due to natural coastal change.
That is quite something. It makes coastal property fundamentally different from owning landlocked property.
Okay, so with these complex moving boundaries and public trust duties, who actually manages all this on the ground? How does the integration work? All right, Chapter 6 deals with management programs. It mandates this clear hierarchy to ensure everyone's pulling in the same direction. At the top, there's a National Coastal Management Program, the NCMP.
It's a big picture strategy.
Exactly. Then each coastal province has to develop its own Provincial Coastal Management Program, BCMP, and each coastal municipality develops a Municipal Coastal Management Program, MCMPs.
And they all have to align.
They must be consistent with the national program, the NCMP, and also with something called the National Estuarine Management Protocol, which we can touch on. It's all about ensuring local actions support the national goals for the coast.
How do they make sure this alignment actually happens? Is there a structure?
Yes. Chapter 5 sets up the institutional structure.
Yeah.
There's a National Coastal Committee, NCC, and then Provincial Coastal Committees, PCCs, and even Municipal Coastal Committees, NCCs, can be established.
The job is
To promote that integrated management and coordinate how the Act is implemented across the different levels of government, making sure everyone is talking to each other and working from the same playbook, essentially. There are also designated provincial-led agencies responsible for coordinating things within their province.
You mentioned estuaries, those tricky zones where rivers meet the sea. Are they handled differently?
They get special attention, yes. Chapter 4 says estuaries must be managed in a coordinated way, following a specific National Estuarine Management Protocol, the NEMP. And importantly, this protocol needs agreement, concurrence from the minister responsible for water affairs.
Makes sense, given the mix of freshwater and marine influences.
Precisely. It recognizes that you can't manage an estuary properly without considering both the river feeding it and the sea it flows into.
Okay, let's talk development control. What if someone, say a big developer, wants to literally create new land by filling in part of the sea? Reclamation. How does the Act handle that?
With extreme caution. Section 7B and 7C deal with reclamation. For any purpose other than the state's own use, it's only even considered in exceptional circumstances.
Exceptional circumstances? That sounds like a high bar already.
It is. And even if it meets that, it's a multi-stage process. You need the minister's pre-approval, you need the standard environmental impact assessments and authorizations, and then, get this, the pre-approval has to be ratified by Parliament.
Parliament needs to sign off on creating new land from the sea.
For non-state purposes, yes. It shows just how seriously the Act guards the integrity of existing coastal public property, including the sea itself. And even if it somehow gets through all that.
There's more.
Yes. The reclaimed land cannot be sold. It has to be leased from the state. So ultimate control stays public, even over newly created land.
Wow. Okay. What about controlling development near the coast, not in it? Are there other tools besides the CPZ?
Yes, Section 25 introduces coastal management lines. The provincial MEC can establish these lines on a map.
Like a literal line on the ground?
No, more like a line on planning maps. It demarcates an area, usually seaward of the line, where future development will either be totally prohibited or heavily restricted.
Why would they do that?
Often to protect public safety, maybe in areas highly vulnerable to storm surges, or to protect the CPZ itself, or sensitive ecosystems. It's another layer of preventative control.
Right. So we have all these rules, boundaries, restrictions. Let's get to the sharp end. Enforcement. What happens if someone pollutes the coast or damages it? What are the Act's teeth?
Well, the general duty comes from Section 58, which basically imports the principles from the main environmental law, NEMA. You have a duty to avoid causing an adverse effect on the coastal environment.
And if someone breaches that duty?
Then the authorities can act. Under Section 59, the minister or the provincial MEC can issue a coastal protection notice.
What can that notice order you to do?
It can order you to stop the harmful activity immediately. It can require you to investigate the extent of the damage, or it can instruct you to undertake specific rehabilitation measures.
What about illegal structures? Say someone built a jetty or a wall without permission and it's causing erosion.
That's covered by Section 60. Repair or removal notices. If a structure in the coastal zone is causing an adverse effect, or if it's built unlawfully in the first place, the authorities can issue a notice demanding its repair or complete removal.
And if the person just ignores the notice?
Then Section 61 kicks in. The state can carry out the necessary work itself, do the repairs, or demolish the structure, and then recover all the costs incurred from the person who failed to comply.
Okay, so financial consequences too. What about specific pollution, like dumping stuff at sea?
Chapter 8 is very clear on this. Section 70 is a strict prohibition. You cannot incinerate waste at sea, period. And you cannot dump waste at sea without a permit.
Are permits easy to get?
No. Section 71 lays out what might be eligible for a dumping permit, and it's a limited list, things like dredged material from harbors, certain types of sewage sludge, fish processing waste. And any application is rigorously assessed against waste assessment guidelines set out in Schedule 2 of the Act.
What about pollution coming from land, like factory effluent flowing into the sea?
That's Section 69. You cannot discharge effluent that originates on land into coastal waters unless you have a specific coastal waters discharge permit, or it falls under a general authorization. It's tightly controlled.
So ignore these rules on dumping, building, access fees. What kind of trouble are you actually in? What are the penalties?
They are severe. Chapter 10 outlines the offenses. The most serious are Category 1 offenses. These include things like illegal dumping at sea, doing unauthorized land reclamation, or charging those illegal access fees we talked about.
And the penalty for Category 1?
It's hefty. A fine of up to R5 million, or imprisonment for up to 10 years, or potentially both.
5 million rand or 10 years. Okay, that's serious. What about lesser offenses?
There are Category 2 offenses. These cover things like failing to comply with one of those repair or removal notices, or unlawfully preventing someone from accessing coastal public property.
And the penalty there. It's still significant. A fine up to R2 million, or imprisonment up to 5 years. And importantly, if you get a second conviction for a Category 2 offense, it gets treated as a Category 1 offense.
So the law definitely has teeth. Okay, let's try and pull this all together. So what does this all mean? We've gone from the Constitution saying the coast is special and held in trust.
Through defining zones like CPP and CPZ, grappling with that dynamic high watermark rule where nature can literally change property lines.
To integrated planning structures, strict controls on reclamation, and finally, these really quite severe criminal penalties for violations.
It paints a picture of a legal framework that's trying to be comprehensive, robust, and adaptive for a very complex environment. It's definitely not just a set of vague guidelines, it's a shield, as you said earlier.
A robust legal shield for the coastline.
I think that's fair. And if you step back, that concept we kept coming back to the state as public trustee is really the philosophical core. Section 12 spells out this duty.
Remind us, the state must ensure CPP is managed in the interests of the whole community. And crucially, it has to adopt a long-term perspective that takes into account the interests of future generations. That long-term view justifies many of the restrictions.
Which leads to a final thought, maybe something for you, the listener, to ponder. We have this powerful dynamic coast, especially with accelerating sea level rise, and we have this strict rule. Natural erosion means loss of private land to public ownership with no compensation.
Right.
So how does the state balance its duty as trustee for the whole community, including future generations who need a protected coast, against the very real immediate loss faced by current private landowners as the sea advances?
That tension between the power of nature, the non-compensation rule in Section 14, and the state's long-term trust obligations is really at the heart of coastal management challenges going forward.
It's that relationship between dynamic nature and the law's attempt to manage it, especially property rights, something definitely worth watching.
Absolutely. It's where environmental law, property law, and climate adaptation all collide.
A fascinating and complex area. Thank you for helping us navigate the ICM Act today and understand its significance.
My pleasure. It's a critical piece of legislation for South Africa's future.
Indeed. A robust legal shield forged to protect a national treasure. Thanks for joining us on the deep dive.